Good afternoon, everyone, and thank you for joining us for today's Legal Brokers and Stuart Title webinar, where we will be looking at the report on title and providing practical examples to help you prepare effective reports for your clients. My name is Stephen Smith, and I'm delighted to be joined by Ian Quayle, my Robert Kelly, and Darren from Legal Brokers. Good afternoon to you all.
Good afternoon.
Before I hand over to Ian, I just want to go over a few items so you know how to participate in today's event. By default, you'll be listening through your computer system. If you would prefer to join over the telephone, you can just select the telephone option in the audio pane and the dial-in information will be displayed. The telephone is toll-free, so local charges will apply, but there are no other charges incurred apart from that. During the session, you will have the opportunity to submit questions to Ian by typing your questions into the questions pane of the control panel. You can send questions in at any time during the presentation, but we will collect these and address them at a dedicated Q&A at the end of today's presentation. You can also raise your hand during the presentation if you're having any difficulties with the sound or any other technical issues. We should be able to speak to you over the chat box feature and hopefully resolve any issues. Also, if you have signed up to the webinar and you're with us today, if you respond to that GoToWebinar email, that would come directly to me. So if you did want to email myself with any technical issues you're having, you can do so just by responding to that email. Finally, we have got some notes today. They won't be available at the start of the session. We're just having some trouble with uploading those, but we will be sending those out at the end of the session regardless. So please talk to me if you would like to receive them at any point. That leaves me just to say thank you to everyone for joining today, and Ian, over to you for the main part of the presentation.
Thank you, Stephen. Thank you, and good afternoon, everyone. A belated Happy New Year. I hope everyone's happy and well. I'm speaking to you from a very remote Scottish island this afternoon, and remarkably, it seems as he touches timber, the internet connection is far better than it usually is from my office. But a massive thank you to Stuart Title for organising today's event. A massive thank you to Legal Brokers and Darren for participating, organising and sponsoring today's event. And again, I think it is important for delegates to understand and appreciate that both Stuart Title and Legal Brokers are supporting the profession with regard to organising CPD events such as this, but they're also assisting the profession with regard to new product ideas, etc. So please have a look at both Legal Brokers website, Stuart Title's website, just to see what they're doing, where they're going with regard to different products. And of course, if you require their services, please contact them. So a massive thank you to all concerned. What we're going to be doing today is looking at reporting on title. We're also going to explore a little bit about scoping the retainer and how that fits in connection with reporting on title too. So lots and lots of things to talk about. As Stephen mentioned, there are notes and slides that accompany today's presentation. I'm sure Stephen and the team will ensure that notes are made available to you. But if there's a problem with regard to slides or notes, I can make them available to Stephen, to Darren and to Robert, who are all involved with regard to sponsorship, and can send them directly to anyone that's attending today just to make life easier if appropriate. The first thing I always do is mention use of websites. And again, over the last few days, I've been spending a lot of time looking at the Property Litigation Association website. And again, it's so useful for transactional property lawyers, because there are papers and opinions written by barristers and KCs on issues that you will encounter in connection with everyday practice, be it professional negligence issues, be it issues with regard to the enforceability of covenant, enforceability of easement, be it what we should be including when we're scoping our retainer, what we should be including in reporting on title. So if you have a minute, if you have an issue or a problem with regard to any aspect of conveyancing, do have a look at the PLA website. There's a wealth of material sitting there for you and it's free to access. Property protocols, I always mention because of the boundary dispute protocol, very useful for giving advice relating to boundary issues, boundary problems, boundary sensitivity and boundary disputes. Where we're reporting on title on leasehold transactions, be aware of the need to explain to clients the bigger picture with regard to leasehold ownership, the various disadvantages of leasehold ownership as opposed to freehold ownership, the duties and obligations that are owed by landlords, and leaseholders with regard to residential leases. All that you need with regard to the provision of background information relating to residential leases, you can find on the Leasehold Advisory Service website and on the Leasehold Knowledge Partnership website. The Advisory Service website pretty much geared to sort of advising landlords, although there's a lot of assistance for leaseholders too. Leasehold Knowledge Partnership is a great counterbalance because there's loads of information there that is useful for leaseholders, particularly with regard to fire safety, particularly with regard to the Building Safety Act and 2022 and how that impacts on leaseholders and landlords. I always mention to practitioners the RICS Consumer Guide to Survey and Valuation. I'm often amazed how few practitioners are aware of that resource. It explains to clients the benefits of survey and valuation. And again, in our reporting on title, we should be telling clients about the need for survey and valuation, the principle of let the buyer beware, and the RICS Consumer Guide gives the client an explanation as to the types of survey that are available and the disadvantage of having anything other than a level 3 survey or valuation. The Association of Residential Managing Agents has a useful leaflet on owning leasehold property, and quite surprisingly, a useful leaflet on estate rent charges, which is quite useful. And then Property Law UK, which is sponsored by Stuart Title, a monthly electronic publication that I own that generates lots of information for conveyancers, residential conveyancers and commercial property lawyers with regard to changes in the law, recent cases, etc. So again, you can have a look at that. That's a subscription service. Everything else is free. Everything other than Property Law UK, I'd thoroughly commend to you on the basis that there's boatloads and boatloads of information that will assist you. Today's webinar is sponsored by Legal Brokers and of course sponsored by Stuart Title. There's the details for Legal Brokers. You already should have the details for Stuart Title, but both Robert and Stephen Smith are there to assist and are attending today in the background along with Darren from Legal Brokers to deal with any questions or queries that you may have relevant to their product. So what do I want to do today? I want to talk about reporting on title. But in reporting on title, I think there are a number of things really that we need to deal with as introductory issues. Firstly, and significantly, in residential transactions, it is absolutely critical that we ascertain client objective. Over the holiday period, I had time to sort of reflect on where conveyancing is going and what's happening. And one of the things that I think is quite interesting and quite useful is that we're seeing a standardization of process, a standardization of searches, a standardization of information that's being produced to the clients, be it reporting on title, be it the availability of searches via search providers, etc., which is all fantastic and all makes the life of the conveyancer a lot easier. But there is a danger that we lose the fact that instead of focusing in on process, at the end of the day, we need to be focusing in on clients, personalizing the process, understanding the needs of the clients, the level of awareness of clients, their attitude to risk, and the purpose behind which the instructions are coming. In other words, why does the client want us to act for them in connection with a sale or purchase? And this, I think, is a theme of the Law Society and SRA, and also a theme of the CQS guidance that we saw amended in May last year. This idea about making sure that we are focusing in on the client. And remember, when we talk about client objective, there isn't such a thing as a collective client. If we're acting for Mr. and Mrs. Jones, it's important to understand and appreciate that Mr. and Mrs. Jones might have different levels of understanding of the conveyancing process, different attitudes to risk. And therefore, it's important that when we're reporting on title, when we're onboarding the client, that we deal with clients differently, depending on knowledge, depending on attitude, depending on stress levels that the clients are facing or encountering. Today's part of today's title is information, explanation and advice. And first of all, there's a health warning. I think these days it is not enough simply to provide a conveyancing client with information. That if we're doing that, we're leaving ourselves vulnerable to negligence claims. When we're onboarding a client, when we're explaining our role, when we're defining our retainer, when we're reporting on title, we must provide information, but then we'll go beyond that and provide explanation and advice. So therefore, we should explain to clients the conveyancing process, explain to the clients the documentation that they're going to encounter in the conveyancing process, explain the vulnerabilities, duties and responsibilities that the clients owe in the conveyancing process. So both of those tasks are quite onerous. With regard to the provision of information, I think there's a danger of overload and overkill. And therefore, one of the things that I would say with regard to clients is that if we can use external resources to reinforce or develop or explore points that we're making, that's useful. And again, I refer back to Leasehold Advisory Service, Leasehold Knowledge Partnership with regard to leasehold transactions, RICS Consumer Guide with regard to surveys and valuations, the property protocols with regard to advice about boundary identification. So the more that we can use external resources to reinforce points that we're making, I think the better, rather than providing the client with a 40 or 50 page report on title. If we can condense that down to 10 or 11 pages or 5 or 6 pages, but then refer to ancillary resources to support or endorse or develop or explore further the points that we're making, so much the better. Clients need also to be aware of their exposure to risk. And here I'm pleased to say I'm the bringer of good news. You're not expected to be an expert with regard to all aspects of property law. You are a transactional property lawyer, and therefore the client, subject to what we do with regard to our retainer, subject to setting realistic client expectation, cannot expect us to be experts in all matters property related. But it's our job to make sure that we're setting realistic client expectation. It's important, and it's our job to make sure that when we're scoping our retainer, we're setting out quite clearly what we're going to do and what we're not going to do. And when we're reporting on title, we've got to be consistent with what we've said before, and we've got to provide information, explanation, and advice in a manner and in a format that clients can understand. Now, before I go to the next slide, I think there are 1 or 2 important points to share with you. Firstly, I've been speaking with one of the largest professional indemnity insurance brokers in the country recently about negligence claims in conveyancing. And what they're saying to me is what professional indemnity insurers have said to me on many occasions in the past. Historically, negligence claims arose as a consequence of procedural failure, failure to do searches, a failure to check title, a failure to properly investigate title. These days, more and more negligence claims arise from poor communication or ineffective communication. And the important point about information, explanation, and advice is that simply providing information to the client, providing a report on title, scoping the retainer for the client, and sending off an engagement letter to a client is not enough. We've got to have evidence that the client has read and understood the information that we've sent out to the client. And also we've got to invite the client to question or challenge or to seek clarification on any points that they don't understand, don't appreciate, or don't get. The first thing I want to talk about is the retainer, the engagement letter. A lot of firms in a report on title will attempt to limit liability or to attempt to exclude liability, or will attempt to limit the scope of the retainer. And at that point, it's too late. So the second point that I want to get over today is this point about making sure that when we're scoping the retainer, when we're engaged, sending an engagement letter to the client, when we're onboarding the client, it's important that we clarify the position. The retainer or the engagement letter can reduce or limit potential liability by telling the client about what we're going to do, but also explaining to clients the limitations with regard to those works, and then explaining to the client what we're not going to do. And this then is reinforced in our report on title. So let's have a look at highlighting the work that's going to be done. We're going to tell the client on a purchase that we're going to be undertaking due diligence with regard to title and the property. Well, what does due diligence involve? We need to tell the client what work we're intending to do on the client's behalf. Consideration of contract, consideration of seller's title, undertaking appropriate searches relevant to the property, undertaking consideration of the TA forms and other documentation that the seller's conveyancer is providing, reporting to the client on the results of searches, reporting to clients on further or additional information undertaken with regard to TA forms, raising additional inquiries where appropriate, advising client of the need for client inspection pre-exchange, and explaining to the client upon the client undertaking an inspection of the property what we want the client to report to us. So those sorts of things are highlighting the work that's going to be done that ultimately is going to be incorporated into our report on title. We need to highlight the limitations relating to the work that we're going to be done. Let's just drill down for a moment. In our engagement letter, in our report on title, in our scoping the retainer, we need to tell clients that we will not be inspecting target property, that we are reliant on the client, surveyor or valuer to report to us issues relevant to the property revealed by inspection. So we need to really drill down here and tell the client just what we want the client to look at when they're inspecting the property and what we're going to be looking at when we're looking at survey or valuation. With regard to searches, it's important that clients understand the scope of the searches that we undertake, the limitations with regard to those searches, and the fact that when we are undertaking searches, there are searches that are essential. There may be searches that are necessary, given client objective, given locality, given nature of transaction, but explain to clients that there are other searches that are available that the client might want us to undertake. Just before Christmas there, I did a webinar with a guy called Stephen Tromans, who's a KC and who's an expert in connection with climate searches, climate change searches and reports. And he was sort of maintaining the argument that you could potentially be negligent if you fail to advise a client about the need for a climate change search or report. My view is that you need to tell clients about the availability of such a search. I don't think you're necessarily negligent if you fail to advise the client of its availability, but I do think it's good practice to tell a client about all the searches that are potentially available. So our colleagues at Legal Brokers can provide advice as to all the searches that are available for target property. Nothing wrong with sharing that information with the client and then telling the client there are searches that we must do, but there may be other searches on the list that are being provided by the Legal Brokers that you would like us to undertake or that might be appropriate given your objective. So highlighting work that won't be done. We're not going to be inspecting the property. We're not going to be able to advise you as to valuation of the property or whether you're doing a good deal or a bad deal with regard to the transaction. Remember, an estate agent is the agent of the seller, and therefore it's not in the best interest of the estate agent necessarily to discourage a potential buyer with regard to a problematical property. And again, the seller's agent, the estate agent, is likely to be siding with the seller with regard to issues or problems associated with valuations, retentions, discounts, etc., relating to purchase price. Client needs to understand that it's not our role to provide advice to the client with regard to valuation issues. We might become embroiled in discussions with regard to reductions in purchase price, etc., but what that reduction is or whether a reduction is appropriate or not is not a matter for us. So highlighting work that won't be done is important in connection with the retainer, and I think that then follows through with regard to our report on title. As far as the retainer is concerned, it's important it's in writing. It's important that we specify what we're going to do and what we're not going to do, because the courts have said in recent cases, Spire and Withers solicitors being the most obvious, but there are others, that where we have not clarified the retainer, where our retainer is vague or ambiguous, that has the danger of generating greater or further liability for us with regard to claims in breach of contract and or negligence. So we need to be careful about specifying what we're doing and what we're not going to do. It is dangerous indeed to deal with issues relating to the retainer in the report on title, because by the time the report on title is produced, it's too late. The client needs to know about the nature of the relationship between our firm and our client when we're onboarding the client, not when we're producing a report on title before we exchange contracts. Again, another point really, before we start looking in detail at the report on title, it's important to understand that we need to manage and monitor the retainer. So where we've clarified what we're going to do and where we're not going to do something, and then during the life of the transaction, an issue arises that warrants work beyond the scope of our original retainer, we need to manage the retainer by letting the client know that we're going to be doing additional work and precisely what that additional work will involve. Again, it's important that we deal with the retainer on receipt of instructions, but that we manage it throughout the life of the transaction. And again, I repeat, our report on title should always be consistent with our engagement letter and consistent with any communication with our client about scoping the retainer. Because if we're in our reporting on title, reporting on issues that in our retainer we're saying we're not going to be dealing with, that vagueness or ambiguity will generate potential problems with regard to a negligence claim. What should the retainer include? Well, the important point here is this case of Midland Bank against Heck, Stubbs and Kemp in 1978. What would a reasonably competent practitioner do in connection with a transaction? The extent of the duty that is owed by a conveyancer is directly related to the retainer, but could be extended during the life of the transaction. It's therefore important that we manage the retainer during the life of that transaction. For acting for a seller or acting for a buyer, there should be clear lines as to what's being done and what's not being done. So tips and traps with regard to the retainer insofar as it relates to reporting on title. Limit the extent of your duty. Be aware that you are required to proffer advice that's reasonably incidental to the task in hand. Interesting analogy here. There's something called the adjacent tooth syndrome in dentistry, namely that if you're going to see the dentist and the dentist is attending to a tooth and he notices that there's another tooth on the same side or on the other side of the mouth that needs attention, it is the responsibility of the dentist to draw that to the attention of the unfortunate patient. The same principle applies in connection with the conveyancing transaction. So if there is something that is not necessarily directly relevant to client objective, but something that could potentially generate risk for this client in connection with ownership of the property or subsequent refinancing or sale of the property, then that issue should be drawn to the client's attention. You are obliged to protect the interests of the client and to report to the client matters relevant to the retainer, and report and advise the client about anything that might materially or adversely affect the interests of client. So just because we've got a retainer, if there's something glaringly obvious that's beyond the scope of our retainer, that doesn't mean that we are not obliged to highlight it to the client. What I say in connection with reporting on title is that we're going to report to clients anything that has the potential to generate risk. And the good news is that all we're required to do is to highlight that there is risk. There isn't an expectation that we're able to quantify just what that risk is. The job is to highlight risk and then suggest to the client what steps can be taken to identify the extent of that risk, either by us undertaking additional work or the client requiring additional work to be undertaken by third parties. Where we are doing that additional work, have a look at the retainer and see what we can do to ensure that if we're extending the scope of the retainer, we're managing what we're doing. Setting realistic client expectation is so important at the start. It's also important when we're reporting on title to client. When we're reporting on title to client, I think it is important to highlight client objective. It's also important to highlight the client's expectations and then to deal with those expectations. It's also important, I think, to explain the limitations of our instructions, to explain the limitations of due diligence, and to explain the limitations of the conveyancing process given what we've done in connection with scoping the retainer. Remember that throughout the conveyancing process, there is an issue of informed consent. A client can only legitimately and legally validly consent to an exchange of contract, consent to proceeding with regard to a transaction, you having disclosed an issue or problem or risk, if the client understands what the problem or risk is. So in those circumstances, we've got to provide information, we've got to provide explanation, and then we've got to highlight to the client just what the risk is. This morning, I was talking to a practitioner about the co-ownership issue. And again, it was the standard situation. client buying a property, unequal contributions by parties, but parties insisting that property is acquired as joint tenants in law and in equity. So what do you do in those circumstances? How does informed consent actually sit in that context? Well, number one, in order to properly advise about co-ownership, it's necessary for you as a fee and a conveyancer solicitor to obtain as much information as is possible from the clients as to their circumstances, so as to be able to consider what would be appropriate given those circumstances. I think the next thing that we do is explain to clients the choices that they have relating to what we've identified as to what might be appropriate in the circumstances. So we offer the whole spectrum of choice, from a joint tenancy to a tenancy in common and equal shares to a tenancy in common and unequal shares. I think then it's important that, given the knowledge that we have with regard to the client's circumstances, we bear that in mind, but then ask the clients what they want to do. And where clients are adamant that they want to own as joint tenants, notwithstanding one is contributing 90% of the purchase price and the other 10%, then it is important that we advise the client about the risks associated with what they're proposing and what they're instructing us to do. There's no need for us to decline instructions, but what I think we have to do is we have to be robust in giving the clients advice on the basis of risk. Look, Mr. Client, what you're doing is you're giving away 40% of the beneficial interest of this property to your partner, your husband or wife, on the basis that at the moment everything appears to be hunky-dory and a very stable relationship between the two of you, but at the blink of an eye, that relationship can turn sour, the relationship break down, the property sold, in which case you've said goodbye to 40% of the purchase price of the property, the beneficial interest of the property, on the basis of what appears to be your goodwill, your keenness to sort of promote harmony in the relationship. So when we talk about the provision of information in that context, client co-ownership questionnaires, important. Explaining to clients choice in a letter, in an email, in a report with regard to co-ownership. Clarifying instruction, and where that instruction is contrary to advice, warning the client about proceeding. So our report on title needs to deal with all of those issues. If we look at another issue and say, right, you know, that our environmental search and report reveals that there's been historical land use that would suggest contamination. Well, in those circumstances, what do? We advise the client, here is an environmental search and report that highlights historical land use that would suggest there is a risk of contamination. The search and report clarifies or quantifies that risk, or alternatively, it doesn't, and therefore specialist advice is required relating to it. I think that's the sort of approach that we have to adopt with regard to reporting on title, to make sure that clients understand that as far as the environmental search and report is concerned, it identifies risk, that we're not in a position to advise a client about the extent of that risk, but there will be reports or additional information from the report provider that will enable the client to make an informed decision as to whether or not to proceed or not. So again, all in all, in each one of these slides, we're sort of highlighting that we're providing information, we're providing where we can explanation, and where a client is at risk, we advise client of that risk and assess what the client can do or what we can do on the client's behalf in order to determine the extent of that risk. As a transaction progresses, it's important that the retainer is under constant monitoring. Even when we're reporting on title, we need to think about whether it's been necessary during the life of the transaction to undertake work beyond the scope of our engagement letter or our email or letter dealing with scoping the retainer. Then when we talk about reporting on title, there are some important points in my view. Point number one, which I've touched on already, I think it is inherently dangerous in producing an 80, 90, 100-page report on title to a client just before we're due to exchange contracts. Why do I think it's dangerous? Because the client is not going to digest the information that we're producing. The client is not going to read and understand all those pages of emails or attachments. So I think the first thing that we can do is break down our report on title into a series of interim reports as the conveyancing process progresses. That it might be possible to explain to the client when we're onboarding the client about the conveyancing process, about the documentation that the client is going to be asked to sign in that process, giving the client advice about the bigger picture of leasehold ownership, giving the client information and explanation with regard to co-ownership, making sure that clients understand when we're doing searches, the purpose of those searches and the limitations relating to those searches. And then when we're reporting on title, we're just sort of reverting back to the information that's already been produced. The next thing I think is to understand what the report on title does. It reports on the due diligence process completed by the buyer. It also highlights certain issues, certain areas of risk with regard to the conveyancing process. A report on title has to be effectively communicated. So I think we highlight client objective or objectives. We highlight what we know about clients and what their attitude is with regard to the conveyancing process, their knowledge, their attitude to risk, for example. We make sure that we provide a summary of our report on title relevant to issues that the client has identified or relevant to client objective. We make sure that the report on title is effectively communicated. So when I'm emailing a report on title to the client, I want to confirm that the client is going to confirm to me that the report on title has been read, that the report on title has been understood, and I'm going to insist that the client, if they have any questions, raise those questions immediately. The purpose of this approach is so that the client cannot say in 3 years, 5 years, or 6 years' time, I didn't read the report on title, therefore I wasn't aware of the dangers of having a joint tenancy. I was not aware of part of the site being potentially used in the past for the storage of diesel and therefore the risk of vulnerability with regard to diesel contamination. I was not aware of a local land charges search revealing a financial charge against the property that is now coming and has now come along and bitten me. So where we have invited the client to confirm that a report on title has been read and understood, then the client can't turn around at a later date and say, I hadn't read it and I hadn't understood it. Well, we've invited a client to generate any questions that they may have relevant to the report on title. It's going to be difficult for the client to say at a later date, I have loads of questions, but I didn't ask them because I didn't think I could, or I didn't think it was appropriate. We've asked the client to ask us questions and the client is silent on the point. A report on title has to be readable, it has to be digestible, and therefore we need to be careful. One, I think we avoid legalese. Two, where we can, we refer to external resources and external sources to assist in providing explanation. We provide the clients with examples of the sorts of things that can generate or highlight risk, so the client understands the implications of a seller not providing correct information with regard to a TA form, or the potential problems associated with part of the garden being a possessory title and nothing more than that. So the client understands the significance of what we're saying to them, not just what we're saying to them. Our report on title can limit and exclude liability. But again, that's subject to the caveat that I mentioned earlier about scoping the retainer. We have to be clear about what our due diligence process involves, about what we've done and what we've not done. And that's where our report on title has to be consistent with our engagement letter and scoping the retainer. Absolutely essential that we always consider the position with regard to the relationship that we've had from the client with the client from the start to the finish of the transaction. So let's just drill down for a moment, and when we talk about the content of the report, just what do we mean? Would I send to a client a copy of all my searches? Well, a matter of choice, to be honest with you. I would prefer it if we, within the report on title, explain the searches that we did, explain the limitations relating to those searches, and explain what the search reveals. It might be that we annex to the report on title a copy of the search itself, highlighting where appropriate some of the points that we've made. In my report on title, am I going to explore the information that the seller has produced in the TA forms? Answer, yes. Am I going to tell the buyer client that where the seller has deliberately lied, has been negligent with regard to the provision of information, or has made an innocent mistake, our client buyer might be entitled to bring a claim for misrepresentation? Yes, but I'm also going to explain to the client that the client is unlikely to have the appetite or the wherewithal to bring proceedings for misrepresentation where such a claim could be brought. Am I going to report on to the client the fact that the rear road to the property is not adopted by the local authority? Answer, yes. Am I going to explain to the client the significance of that? Yes. In other words, am I going to tell the client that you have a right of access and egress at all material times along the private road, but the private road is owned by a third party? Therefore, there could be issues and obligations arising with regard to repair and maintenance. It might be that we can explain what those duties and obligations are. It might be that the easement that enables access and egress at all material times is silent on the issue of repair and maintenance, in which case the client needs to be aware of the potential risk associated with having a right of access, but the private lane being a sort of dirt track or a muddy track, depending on the amount of use and the season of the year. The content of the report should explain what the mortgage offer reveals, should explain what the survey or valuation reveals, should explain what's been decided with regard to co-ownership, should explain the position with regard to what's been revealed by client inspection, where a client has inspected and reported to us that there doesn't appear to be anything of concern in the nature of, say, an overriding interest or third-party rights. I think our report on title should stipulate quite clearly, you've inspected the property, we've told you what a reasonable inspection requires, and you've confirmed to us that your inspection reveals nothing of concern. Again, frequently when I look at firms reporting on title, the issue of client inspection and what the client has or hasn't reported to the firm having undertaken an inspection is quite worrying, on the basis that frequently clients don't understand what they're looking out for, and certainly are not told of the significance or importance of reporting to you what they see or what they find. Just taking that a step further, I think it's important that when we're advising clients to inspect target property, we tell them what we're asking them to look out for. Whether or not the information in the TA forms is correct, whether or not what is revealed by the contract as a description of the property and the title plan is consistent with what the client sees, whether the client is satisfied as the state and condition of the property, and whether the buyer has checked what the surveyor or valuer has revealed in his survey or report, that the client buyer is aware that they are potentially bound by interests which are obvious on inspection of the property, but which are not revealed by the seller in connection with title. So it's important, particularly with regard to client inspection, that we deal with that issue in the report on title, just in case the client is going to be bound by something due to the doctrine, for example, of constructive or actual notice that we haven't reported on. The reason that we haven't reported on it is the client hasn't made it aware to us. The other thing I think that's important with regard to the report on title is that there should be a conclusion or summary. And the other very important point with regard to reporting on title is that once we've submitted a report on title, we should not think that that's the end of the story. If we become aware of information that is supplemental to our due diligence process, whether that information is disclosed to us before exchange or after exchange, there is an obligation on us to report it to the client. Reporting on title is important. There is a balancing exercise between overkill with regard to providing the client with everything and anything on the basis that we're protecting our own necks, At the same time, we're trying to provide information to the client that's going to be meaningful and useful. And that balancing exercise requires us to know our client, to know our client's potential vulnerabilities, and to know our client's attitude to risk. The report on title has to be consistent with our engagement letter or our emails or correspondence in which we are scoping the retainer. And what we've got to do is to make sure that we protect ourselves by ensuring that the client is confirming to us that the report on title has been read and understood. We further support or back up those statements by inviting the client to ask us questions that they may have relating to the report. A number of practical points. If you're acting for more than one buyer, the report on title should go to each. Sometimes you'll get instructions from co-owners that will say one of us is busy working away, etc., and we're not going to be able to have the time, nor indeed the inclination to communicate with you in connection with the conveyancing process. Even though I've been told that, I would always want the quiet client, the silent client, if I can call them that, to be provided with a copy of the report on title and to confirm a reading of the report and understanding of the report and inviting questions. Next thing with regard to reporting on title, is it necessary to go through with the client the report on title virtually, or if we're still seeing clients, actually sitting down with the client and going through the process? Again, it's a matter for you. What I would say is that if you're going to sit down with a client and discuss a report on title, it's important that we make a note of the attendance. And at the end of the attendance, we repeat the point that I made earlier. We say to the client, we've discussed a lot today. Have you understood everything? Do you require any clarification or amplification of any of the points that we made? And do you have any questions? And if nothing else, I would, in my noting the meeting, virtual or otherwise, note that I've asked if they've understood and they've said yes. I've asked if they needed any form of clarification or amplification and they said no. And I've asked if they had any questions or queries and they've said no. I would also invite a client that I'm meeting virtually or face-to-face, if they do have any questions going forward, that they should ask them as soon as possible, on the basis that once we've exchanged contracts, it is unlikely that we will be able to extract ourselves from the contractual relationship with the seller, notwithstanding any information or dissatisfaction that the buyer client then feels. Hopefully that all makes sense. 2 or 3 things to explain to you. One, there are a number of products now that will enable you to have a template or a report on title that you can buy into, using artificial intelligence to migrate data from the land registry and searches into the report on title. Do I think they are good things? Answer, yes. Why do I think they are good things? One, they provide a template or a structure for reporting on title. 2, they encourage fee earners within firms, no matter what levels of experience or knowledge, to do a standardized form of report on title, which is good from a CQS compliance perspective and also good from a professional indemnity perspective. Certainly insurers and insurance brokers are very keen to see firms having standardized processes. I think significantly enables us to take a little bit of time to think about the point that I made at the very start of my presentation today, the fact that what we should be doing is looking at clients as individuals and not looking at clients as sort of a standard client in a standard transaction. So that the use of a template report on title, an electronic report on title using artificial intelligence should enable us to free up time to think about the client's position and the client's perspective. Certainly on talking to fee earners and members of staff, both relatively new and relatively experienced, all have said that the idea of having a report on title that can be used day in, day out has major benefits. There are disadvantages. Just as with any form of standardization, any form of template, any form of precedent, there is a danger that the precedent, the standard form, is misused or abused. And I need look no further than a recent decision of the Solicitors Disciplinary Tribunal, where a partner fee earner was fined £10,000 for professional misconduct having produced over 120 reports on title to clients who were buying properties on a leasehold development where the landlord developer had altered its standard lease, but the firm's standard report on title with regard to properties on that development had not been altered to mirror the change in the form of lease, which I think was a change in provision with regard to variable ground rent. The other point with regard to reporting on title is that it is not a tick box exercise. It's not a standardization exercise. It's the provision of information, the provision of a communication that enables a client to have informed consent relating to the transaction. And that is so important. Going forward, there is a wealth of case law dealing with reports on title, which I include in the notes. Orient Field Holdings, AW Group and Taylor Walton confirming the same thing. When you get a search in, you've got to explain to the client the result of searches. Where there are results that are adverse to client objective, these need to be reported to the client. The client needs to be made aware of risk or vulnerability and made aware of what further steps can be undertaken in order to define the extent of that risk or vulnerability. Moda International brands against Gately, Minkin against Landsberg, both sort of confirming the dangers of familiarity, not keeping records of client attendance, not being aware of client objective, not tailoring work to that objective. Spire Property Development and Withers 2021 decision subject to Court of Appeal in July 2022. Again, Withers solicitors being able to robustly defend negligence claims on the basis that they had scoped the retainer, such that any reasonable client would fully understand what the firm was going to do and also what the firm was not going to do as well. Interestingly, Spire Development also highlights the dangers in connection with providing a report on title to a client, concluding the transaction, closing the file, and then a client contacting your firm asking for clarification or amplification of a point that was made during the conveyancing process. The important thing I think here is that where you have a situation where your file is closed and the retainer has ended, what's the position where a client rings you and says, hey, I've been talking to the neighbour and there's an issue with regard to a boundary wall or a hedge and repair and maintenance issues. In such circumstances, what I think we can extract from Spire and Withers is that what we should be doing is providing the client with a copy of the report on title that we sent to the client during the retainer. Or we invite the client to instruct us with regard to seeking advice with regard to the problem that's just been generated, and then calling for the file and then giving further or additional advice if you feel comfortable doing so. But I think there's an inherent risk in a client contacting you and a client then seeking advice or clarification, and you're providing that advice or clarification on the hoof, as it were. Certainly in Spire Property against Withers, Withers got themselves into a bit of a mess as a consequence of giving advice to a client in connection with an exchange of emails following closure of the file. And then there was an issue about what was the retainer, what was the scope of the retainer, etc. A number of things you can extract from cases is that, generally speaking, in conveyancing transactions, there isn't sort of a general retainer. In other words, there's an obligation on a solicitor or conveyancer to give ongoing advice to conveyancing clients. When the transaction is being concluded and the file closed, the retainer is at an end. And where the client therefore requires further information or advice, that would generate the potential for a new retainer relating to that advice. Moving on, we've got time for questions. And I don't know, Stephen, whether there are any questions, but if there are, we can deal with them. If there aren't any questions, there are a number of points that I'd like to make. Firstly, with regard to reporting on title, one of the things that I haven't covered so far is the issue of defective title insurance. And I do think, and it's a point that Robert and Stephen and I have discussed on many occasions in the past, it's important that clients understand that where there is an existing defective title insurance policy or where a new title policy is being taken out, that the client understands the limitations or the scope of that policy. and that the client understands that a defective title insurance policy is a way of resolving problems relating to title defect, but it is one of a potential number of different ways. So again, it's being realistic with clients and setting realistic client expectation. The problem, the defect in title remains. We have a solution to that problem. The solution is a defective title insurance policy. Here's what the policy does. Here's what the policy covers. But Mr. Client, you've got to be aware the problem remains, and the taking out of a defective title insurance policy generates obligations and duties on you with regard to the insurer. Stephen, Robert, I don't know if you've got any comments to make with regard to that point, but I do think it's important to ensure that when we report title to clients and there is a defective title insurance policy, the report on title deals with it. And again, we're setting realistic expectation. Robert?
Yes, Ian, I'd agree with you. I think the key point that we always try to stress is it's a solution, not the only solution. And also, I think as practitioners, we need to bear in mind that, particularly on residential transactions, title insurance deals with market value, financial value, but there's a whole heap of emotional value and input into a property purchase. And people do need to understand that it's not a magic wand to get rid of the problem. It gives you funds and support to fight the problem and ultimately diminish it in value. But you may still lose your dream house. So that emotive value needs to be explained to the client as well when telling them about the benefits of a title policy.
Yeah, great points. Thank you for that, Robert. Stephen, are there any questions?
Thanks, Ian. Yeah, we're a bit quiet on the questions front today. So just quick as a reminder to everyone, you can submit any questions you have to in the questions pane of the control panel. We will leave this open just for a minute or so, and if there are no questions, there are no questions, of course. But just while people are maybe considering a question to ask, we'll just run a quick poll if that's all right with yourself, Ian.
Yeah, of course.
So the question is, on a scale of 1 to 5, what is your view on the outlook for the housing market in the next 6 to 12 months? I've just launched this poll now for you all to consider that. Obviously, a scale of 1 to 5, with 1 being a very uncertain future for the property market and 5 being booming with no problems. So we'll just keep that open for a while.
Yeah.
Ian, you've in recent months you've definitely sort of been very bullish about the outlook for the market. Would you sort of maintain that at the moment, or?
I do. I'll tell you why. I think that as far as the market is concerned, there's a number of false premises. False premise number 1, that it's gloom and doom time. I think what we've had is 3 years of extraordinary circumstances where it's been boom after boom after boom. So I think that if there is a sort of hardening of the market, if there is a sort of a downturn, it's a downturn back to where we were in 2019 or so. So I don't think it really is a downturn. I think it is just a sort of a leveling off or going back to what were the good old or the bad old days. The second thing that I think is important is to look at the sort of the market generally and business generally and employment generally. And although people are saying times are harder, although people are quite rightly sort of bleating with justification about the cost of living and all that goes with it, as far as unemployment is concerned, I don't think we're seeing drastic and radical unemployment as we have in the past. And as a consequence of that, I think there are still people that are going to be needing to move or wanting to move. And I also think that you're going to have a situation where, because times are hard, people are selling, and there's still money around and there's still sort of hard cash around to enable people to take opportunities where people are selling. So I am far more optimistic than I have been. I think if we make some assumptions that, God forbid, this horrible situation in the Ukraine resolves itself once and for all, and that relieves a log jam with regard to fuel and all that goes with it. Once the sort of the COVID situation, the flu and the winter sort of subsides, and all these health issues that are causing problems subside alongside it, I think we're going to see a bit of a bounce back, or a lot of a bounce back, depending. it's very interesting, Stephen, looking at your poll here, that the market is stable enough. 55% are thinking that. And all right, yeah, there is some uncertainty, but there always is, isn't there? And I think, you know, as far as residential conveyancing is concerned, there's a base level of work sitting there for people to do. Commercial property, different thing entirely. The moment funders and lenders are saying our doors are shut and we're not lending for commercial development, then I think commercial developers very quickly say, right, enough's enough. And sometimes it takes an awful lot for them to become excited and to get back in the marketplace. But as far as the general position is concerned, I think for residential conveyancing, we're not going to have a brilliant year, but we're not going to have a rubbish year either. I think it's going to be a steady year, a reasonable year. The interesting thing, Steve, I don't know what you're seeing, but I'm not seeing vast numbers of residential conveyancers being laid off. What I'm seeing is lots of firms saying what we need to do is perhaps look at our systems and processes and become more efficient. I think perhaps we should be looking at more training for staff to try and upskill staff. But I haven't spoken to anyone that said, you know, it's the end of the world and we're getting rid of 25% of our residential conveyancers. I'm seeing people retaining staff and just thinking to themselves, it might be a bit bumpy for the next 6 to 12 months or so, but it's not going to be so bumpy and the world's not going to end. Anyway, enough of me, Stephen. What do you think and what do other people think?
Well, no, I mean, just very briefly, you know, I'd agree with that sentiment. I was at an event quite recently, and the general mood was quite bullish there, and we see it in our own, you know, our own business. Yes, we're at the end of the transaction, but yeah, and there has been a slight reduction in the amount of inquiries and issued business, but it's that time of year as well. So if you're looking back at previous years, we're still holding on quite well, and it's in a way quite surprising, but very positive, really. So
yeah, I think so. And again, you know, part of me thinks that, you know, when you're watching the news all the time and it's strikes and it's, you know, the fuel bills and cost of living and all that goes with it, yeah, it is very negative and it's very depressing. But you know, when people start actually looking at their own lives and their own circumstances, we need a home. Okay, it might be that we have to think about selling a home and getting something less cheaper or less cheaper to run, etc. But we still need a home. And if we're seeing a situation where the conveyancing market is declining and declining rapidly, and we're then being forced into thinking about renting, etc., well, that becomes a whole new minefield, etc. And I'm not seeing people sort of panicking and thinking, right, let's sell up and let's rent on the basis that the property market is going to fall off a cliff. So again, yeah, perhaps I'm very optimistic, perhaps I'm very foolish, but so far I'm pretty optimistic that, yeah, we're in for some bumps, but we're not falling off a cliff.
Absolutely. Thank you, Ian.
Yeah.
We have had a couple of questions in. I think we waffled on long enough for people to just shut us up with questions.
Waffled on, Steve. Hang on a minute.
Indeed. Yeah. But yeah, so the first question from Matthew Smith, and Matthew asks, he says, "Hi Ian, thank you for the webinar. I have a question. At what point in the process would trigger you to send the leasehold freehold report to the client?" And he follows that up with a couple of points. He says, for example, would you report while you're still waiting on the last 1 or 2 inquiries to be answered in the interest of time, or is upon receipt and review of the contract too early?
Great question, Matthew. Thank you. Listen, this is how I would deal with it. I think if you're dealing with a leasehold transaction, when you're engaged, when you're onboarding the client, when you're sending off your engagement letter, when you're scoping the retainer, hey, Mr. Client, you're buying a leasehold property, you need to be aware of the bigger picture with regard to leasehold ownership. That's what CQS have suggested with regard to their amended guidance. That's what the SRA have been bleating on about since 2017. So I would give the client a copy of the Leasehold Advisory Service guidance about leasehold ownership, or the Association of Residential Managing Agent guidance about leasehold ownership, or I would provide the client with this brief report saying, you're buying a leasehold property, you need to be aware of the following. 1, you're going to be committing to service charge, which is potentially unascertainable going forward, but which will be an ongoing commitment. If we're taking an assignment of an existing lease, you're committing to a ground rent and ground rent review provisions, which again may be unascertainable going forward. You're committing yourself to duties and obligations that you owe to the landlord with regard to repair, with regard to alterations, with regard to use, etc. So I think we do that right at the very start. I think as soon as we get the lease in, we then explain to the client the terms of the lease. So again, we're providing information. There's a copy of the lease, but here's an explanation as to the lease terms and how those lease terms will impact on your ownership. So I think you're doing that as a piecemeal, on a piecemeal basis. The report on title should deal with the leasehold title that the seller is offering and should perhaps provide a commentary with regard to the superior title out of which the lease is derived. I would do that in my report on title, which I'm producing just before I exchange. So I hope that answers that question, Stephen.
That's very thorough. Thank you for that, Ian. Thanks, Matthew, for the question there. Yeah, Matt's gone back and acknowledged that as well. Matthew has, sorry. Just one final question then, Ian. I think we've just got about enough time there. From Louise. Louise says, there is a never-ending list of things we need to alert our clients of, and now also a summary of the main report on title and various other steps to ensure they're read and understood. Dealing with a complex new build leasehold, for example, there is an almost never-ending list of limitations and possible risks to advise on. And the more I look into it, the more I fear I'm not providing a succinct enough report on title. There are search providers who provide auto-generated reports on title. Do you feel these are better or worse placed to provide a thorough report on title?
Right, great question. Thank you, Louise. A number of things. I think they provide a template. Okay, I don't think they're necessarily the complete answer. They are a reminder of some of the key issues. Louise, I have every sympathy with you. New build leaseholds are a nightmare. And the CQS guidance, the changes to guidance, the stance of the SRA, I think puts just about an impossible burden on a conveyancer in advising clients about risk. What I would say to Louise is, one, have a look at the Leasehold Advisory Service or the ARMA, Association of Residential Managing Agents, guidance about leasehold ownership, which I think helps with regard to providing clients with background information. Have a look at the Leasehold Advisory Service guidance leaflets or links, which again can assist. But I think what we've got to do is take a view. And again, it isn't enough just to give a client a copy of the lease and say, read it. We have to provide an explanation as to the lease and the terms of the lease, such that the client can understand it. And yeah, you know, using the search providers' precedents and reports that they are generating, I think, are really useful, but it's a tool. It's not an end game, as it were. It's not a solution. Okay, it enables you to think about some of the issues that could impact on client objective. For example, Louise, firms now that I've been speaking to recently have sort of questionnaires that potential leaseholders complete that potentially highlight to the firm issues associated with risk. So there's one firm that has a sort of series of questions about pet ownership. And if the potential buyer says, well, yeah, we have cats or we have dogs, then what the firm does in the report on title is focus in on what the lease says that would restrict the use or keeping of pets in the premises. I was talking to someone else recently who now has in the report on title a stock section on Airbnb letting. And that stock section, in essence, is saying most residential leases will not enable you to let your flat or your apartment for Airbnb purposes. It's this sort of thing. So to answer the question, Louise, I think using templates for reports on title are brilliant, provided they are a template, provided that we are checking the information that is being migrated in there and then making sure that we're personalizing the report for the client's objective, for the client's attitude to risk. I have every sympathy with fee earners on the basis that, you know, it's overkill. We're providing too much information and therefore we're diluting the benefit of the key issues that we need to report. That's why I think the use of a summary is useful. So we're going to provide a report on title telling the client everything, but then we're going to say, given your objective, these are the things that you really need to know about. But again, Louise, I think it's important that we scope the retainer, or when we're setting when we're onboarding our client and providing the client with an engagement letter, we can upload a lot of data and information from the client right at the start to provide information and background that means that we can lighten the load with regard to the report on title before we exchange. Great question, Louise. I'm doing some work at the moment on reports on title, and again, if anyone's interested, I've looked at the sort of Law Society model and produced some notes on it, and I'm doing some more work on it at the moment. Stephen, what I'll do is share with you that work when it's finished, and you can share that with delegates that have attended today. It might be of some interest. Anyway, thanks for that question, Louise. Any other questions, Stephen?
I think that's it for the questions, Ian. So if you're happy, I think we'll wrap up the webinar there.
Well, thank you, Aaron, for inviting me along.
Yeah. No, thank you, Ian. And I also want to say thank you to Legal Brokers for sponsoring this event, and thank you for Darren for his attendance. Thank you to all of you for attending and the questions as well. If you do have any further questions, please do contact myself or Ian. As I said at the top of the webinar, once you leave today's webinar, you will receive an automated email from GoToWebinar. This comes to me directly. So if you do want to submit any questions, you can do that way by replying to that email. And if you have any feedback as well for myself or for Ian or for Legal Brokers, then please feel free to get hold of us on that channel. You'll also receive a separate email from my colleague Robert Kelly that will include the slides and the notes for today's session and a recording as well. So that leaves me to say, on behalf of Stuart Title, Legal Brokers, and Ian Quayle, thank you all for joining us today, and have a great rest of your day. Thanks everyone, goodbye.